everyone. Thank you so much for joining us today and participating in today's Time to Talk webinar. This is our second. If you missed the first one, I invite you to go to the Young Lawyers Conference page or the Diversity Conference page on the Virginia State Bar website, where you can see a recording of the first one. This presentation today is also sponsored by the Young Lawyers Conference and the Diversity Conference. My name is Mallory. I will be covering a few of the housekeeping items today before we get started, and I turn things over to Zeta Thompson, today's moderator. Comments made during this webinar are the sole expression of the speaker, not on behalf of the Virginia State Bar, and do not necessarily reflect the views of the organization. I will now turn it over to today's moderator, Zeta Thompson. Thank you, Zeta, and panelists for being here today.
Thank you, Mallory. Good afternoon. This is a town hall meeting collaboratively organized by the Virginia State Bar Diversity Conference and the Young Lawyers Conference. The format for today's town hall will be 3 panelists. The first panelist will present. There'll be, at the close of that presentation, there'll be an inter-panelist discussion followed by participant questions. Then we will proceed to the next panelist in the same manner. At the end, should time permit, we will take additional questions from the participants. Now, the purpose of the town hall is to discuss issues related to the removal of statutes. Throughout the history of this nation, there have been flashpoints where this nation has had to face issues of racial bias and racial inequities. Presently, issues regarding statutes commemorating the Confederacy situated on public grounds across this nation, once again, has raised legal issues related to racial bias and racial inequities. Today, we have an impressive panel that will provide historical context for the statutes, speak to the local and state legal challenges in the removal of the statutes, discuss related First Amendment issues, and how the removal of the statutes has enveloped the right to speech as well as property rights. It is our hope that you will find this town hall informative and engaging. On that note, I will introduce our first panelist, Mr. Henry Chambers, Jr. He is a professor of law, an Austin EO and research scholar at the University of Richmond. He teaches and writes in the areas of constitutional law, voting rights, employment, discrimination, and criminal law. A recent work of his, Curating Campus Speakers, considers how free speech and academic values do and do not mesh on college campuses. Currently, he serves as a member of the Governor's Commission to examine racial inequity in Virginia law. Professor Chambers' academic interests and scholarships have also led him to serve as a Special Assistant Attorney General for the Commonwealth concerning Virginia's redistricting after the 2010 census. Say that, it's a mouthful. As a member and currently Vice Chair of the Virginia Indigent Defense Commission and as an advisor to the Virginia Model Jury Instructions Committee. He has been a member of the American Law Institute since 2002. Professor Chambers, thank you for joining us. My first question to you is if you could please provide historical context regarding the placement and timing of the statutes.
Absolutely. Good to be with you today. So we want to take a step back. I'm going to talk about the Richmond statutes in particular. And if folks want to jump in and talk a little bit more about other statutes, that's perfectly reasonable as well. So we want to take a step back to 1865, right? At the end of the Civil War in Richmond. Obviously, we know who won that war, and Richmond was on some down times, a little tough times. So we move forward to 1870. We get to the death of Robert E. Lee, as well as the passage of the 15th Amendment, allowing African American men in particular to vote, or at least restricting states from stopping African American men from voting based on their race, color, previous condition of servitude. Now, the reason why we take that step back is so that we can now move forward a little bit. So the first statue goes up on Monument Avenue in 1890, and that's the Lee statute. So we're talking 25 years after the Civil War. We're also talking about a time when you had African Americans serving in the Virginia General Assembly. A lot of folks they sort of forget when we say, yes, so-and-so was the only governor, or for example, Doug Wilder was the first governor in the US since Reconstruction. because during Reconstruction, there were a lot of African Americans who were serving in state houses, et cetera. And the same thing is true in Virginia. We had a number of folks. It wasn't just a one-off. There were a number of African Americans who served as legislators. So consider that. You lose the Civil War to 1865, a number of African Americans serving in legislative places. Then you get to the end of Reconstruction and then pass. At that point, you have a desire to recommit, or at least some people have a desire to recommit to notions of white supremacy. Surprise, surprise, Lee's statute goes up in 1890. That goes up in 1890. In 1902, we have a new Virginia Constitution, which attempts to disenfranchise African Americans and does a pretty doggone good job of it. We will not see African Americans come back to the State House for another 6 decades. 5 years after that, we get the second and third statutes. Jeb Stuart and Jeff Davis go up on Monument Avenue. There's no surprise that this kind of thing is going on. Now you're back into the ascendancy of white supremacy. You have these statutes go up to remind people of how glorious in theory the Civil War was, or at least how the folks who fought were fighting for something bigger than mere slavery. That is the notion. We then fast forward another dozen years, 1919, we're at the end of World War I. You're in a situation where you may well have African Americans coming back from World War I thinking that they may very well be able to enjoy some civil rights that they had lost over the last 40 or 50 years. And what happens? Well, the Stonewall Jackson statue goes up in 1919. Now, obviously, folks have been raising money for that for a while, but it's fair to say that the notion that African Americans were attempting to make more of a place in Virginia society than they had before is one of those reasons to think that, hey, we're going to step back and we're going to put this statue up just to remind folks once again what's going on. We get the Red Summer in Chicago in 1919. We get the Tulsa slaughter in 1921. Some people will call it the Tulsa race riot, but in fairness, that's not really what it was. It was simply a slaughter of African Americans in 1921. Then in 1929, Matthew Morey goes up, the last Confederate statue to go up on Monument Avenue. So that's sort of the background of statues going up and what was going on in the background as those statues were going up in the foreground. Obviously, Arthur Ashe comes a bit later. He's quite a different part of the story.
All right. So although the removal of these structures is usually a property rights issue, the removal of the statues has also presented First Amendment issues. And given the history of these statues and what they may represent, should we view the statues as government speech? And if so, what obligation does the government have to take them down?
Yeah, it's a great question, because the simple answer is yes, they are government speech. It's a little more complicated than that, but fundamentally they're government speech. That is, these are statues that were either erected, well, they were erected by private individuals, but given to the state. There's the state and the city. They're on either state land or city land that is controlled by the state or the city. Essentially, they amount to government speech. We've had actually a couple cases relatively recently out of the Supreme Court talking about issues of let's say, stuff on public property. We had the Pleasant Grove versus Summum case, which was talking about not a memorial, but a statue or a monument that was going up in a public park. The argument that the folks who wanted to put the statue up or the monument up was, they said, well, this is our First Amendment right to do this because in this park, there are a number of other memorials or statues that are already up. And the city said, well, no. We accepted those monuments on behalf of the city. They are the city's monuments now, and displaying them, or the choice to display them, is the city's right, the city's speech, and the choice to not display them is the city's speech, not a negation of the speech of the person who wants to give us this monument to put on public property. So you have that piece of the puzzle. You also have the Texas license plate case, where the issue that popped up was that the sons of Confederate veterans wanted to have a license plate in Texas. Texas runs a program like Virginia does, where a number of people can get together, get their own license plate. It is a state license plate, but you have your own stuff on it. And what the state of Texas said is, it's still our property, it's still our speech. That is, even though a private entity wants to create a license plate, or at least create the design of the license plate, and even though that is the thing that the private individual wants to do, that license plate itself is essentially the state's real estate, and as a consequence, the state at least has a right to regulate, because it's government speech that's going to be on that license plate. So as a consequence, the state had a right to say, no, we're not going to allow this particular design on the license plate. So you add those things together and you start to say, well, yeah, if there's something on public property that the state or the city or the government allows to be there, that thing in and of itself becomes government speech. Whether it should be taken down or not depends on what we think the government should be saying. But the speech is the government's speech, and as a consequence, it's not really a pure First Amendment question.
Interesting. So in instances where these statues are on private property, and if these statues are deemed a form of speech, does the First Amendment protect the right to offend? And if so, at what point does the offense cross the line to unpermitted speech?
Sure. There's a pretty good argument that says there's no real right to free speech unless you've got the right to offend. Now, I don't think that means that folks ought to walk around offending people just for kicks. But the question is whether the government can stop you from offending someone. And generally speaking, if you're not talking about, fighting words, if you're not talking about an incitement to imminent violence, if you're not talking about true threats, then speech, generally speaking, is allowed, and that speech includes the right to offend. In theory, the response to becoming offended is to respond or to interact or to just leave, right? So if you're talking about speech that's on private property and that speech generally offends, unless there's some other contractual right that's going on there, the mere fact that someone is offended by something on an individual's private property isn't necessarily a problem. And it would be a problem if the government stepped in and said, you've got to take something down on your private property, not based on contract, but just because it offends people. That would be a problem. Like I say, if there's something more than that, then that's a different story. About 25 years ago, we had the Burning Cross case, which raises a slightly different set of issues, which goes more at the question of, are we talking about behavior that is in and of itself illegal? So that's sort of the difference there.
And so that would be the point where it would be unpermitted speech?
In that situation, if the government has sort of a reason to believe that the speech is being made to incite violence, right, then you can say, hey, that's a crime, that's a problem. But if it's purely about offense and causing someone general distress as opposed to fear of harm, then on private property, that's largely going to be up to the person to take down as they wish, but not something the government can take down.
And so, as to the removal of statues, does removing statues frustrate or violate the First Amendment rights of groups who support the statues not being removed? And on the flip side, does not removing the statues result in compelling speech that violates the rights of citizens? Yeah,
that's a hard sort of more theoretical question. And obviously, I'm more than happy to go into the theoretical world, right? When we're talking about sort of pure First Amendment values, or I should say pure First Amendment doctrine, we'd say it's separate. That is, if the government wants to speak, fine. If the government wants to not speak, fine. If they want to take it down, fine. If they want to put it up, fine. Now, we may have problems and concerns as citizens in terms of saying, I don't want my government doing that, or I want my government to take that down, but that really gets at more First Amendment values as opposed to actual doctrine. Now, in terms of the doctrine itself, it might be, in terms of values, it may be worthwhile for us to say, it might be a good rule of thumb for the government to not do things that are going to offend their citizens. It's not to say that they can't, but it is fair to say that's a pretty good rule of thumb. And what we ought to be thinking about when we think about First Amendment or non-First Amendment is, how do we use First Amendment not just as a way to annoy people, but how do we use it to move our country, our city, our state forward? Now, I realize that there are some folks who would say, whoa, that's not what free speech is for. It's just to allow people to do whatever they want to do. But I do think it's fair to say that when we think about First Amendment values, right, the general notion of values and the general notion of the ability to offend is not so that we can walk around and annoy people. Hopefully, it's to say things that might offend as a way to continue the dialogue as fellow citizens and non-citizens about how we should live and how our country gets better moving forward.
Okay. So on that note, if any of the other panelists, Mr. Heitens, Mr. Melita, do you want to add anything further to Professor Chambers' presentation? Please do so. Just let me know which one of you two would like to speak first.
I do have a pretty short follow-up, and if I can go first, it's a little bit of a segue as to where Hank left off. And that was when he talked about, well, we need to think hard about not just protecting the First Amendment, but using it in a way that advances our community's values or our society's values. And I'll remind our listeners, I know the panelists know this already, but I'll remind the listeners that the most protected type of speech under the First Amendment is what's called political speech. It's generally, the court has built two sort of buckets for speech that might be protected by the First Amendment, and it's commercial speech, and some people call it non-commercial speech, but they also call it political speech. And I think that's a better term because it's the type of speech where people are wanting not just their elected officials, but their neighbors and friends, and even people who aren't their friends, to hear what they have to say. And so to the extent that's the most important element of the First Amendment, to protect people's ability to state their political values, that's really one of the essential tools for us to have those kinds of discussions about what do we want our community to be and what are our values, and having those kinds of debates. We get to have them every other Tuesday in front of our city council at public hearings. They're a little bit funny now with COVID and Zoom, but we still have them, and that is the forum for us to be able to give everybody an opportunity to be heard and to listen. So that's why I thought that was a good segue as to where Hank left off, to remind people that political speech is the most important type of First Amendment speech, and it's kind of the tool for how we get to that communication with each other.
And Toby, anything further you'd like to add? No?
Nope.
Well, okay, so I actually have a question from one of our participants, and I believe this is directed most likely at you, Hank. So the question is it still government speech if the government gives its statutes to private individuals? Is the government still speaking if it gives the statute to private corporations and so forth?
Yeah, I think the act of giving the statue to a private entity is probably the last piece of the speech that's there. Once that individual has the property, however, as long as it's not on public ground, I think it becomes private. And at that point, you sort of move on. Now, there may be a number of various procurement issues to get around. That is, if the government has a valuable piece of property, it's not clear that it can just give it away, right? But that's not so much the First Amendment question. That may be a question of, of corporate waste and things along those lines. But yeah, but I think that, I think the last act of giving it away, that may be speech. But once the other person has it, they can do with it largely what they want.
So I don't think I have any more questions from the audience. So our next speaker is Adam Melita. Mr. Melita is a deputy city attorney for the city of Norfolk. He regularly advises the Planning Commission, Board of Zoning Appeals, the city assessor, and the Commissioner of Revenue. Obviously, very heavy on property rights here. He has worked with Norfolk for over 18 years and has litigated in state and federal courts on issues ranging from zoning, real estate tax, condemnation, inverse condemnation, and the First Amendment. Prior to joining the city attorney's office, Adam was a staff attorney for the Legal Aid Society of Southeastern Virginia. He was counsel in a recent matter against the Commonwealth regarding the removal of a statue honoring the Confederacy. So, Adam, my question to you is, your locality attempted to remove a statue before the issue even achieved national recognition as a result of the Charlottesville rally. So please discuss Norfolk's legal progression in removing a statue from property owned by the locality.
Sure, and a little bit of the background I'm gonna give you is gonna, I think, fit really well with the context that Hank laid out with the history of what was going on around Virginia. I don't think Norfolk's experience was that different. So just to put a timeline on it, it was August 12th. I think it was the second day of the situation in Charlottesville, incidental to the Unite the Right rally, when Heather Heyer was run down and killed by a vehicle being driven by James Alex Fields Jr. 10 days later, the Norfolk City Council adopted a resolution that said that they would move the Confederate monument that is located in downtown Norfolk in its central business district. Their intention, they asked the city manager to consider doing or to do, was to move the monument to the Elmwood Cemetery, which is an old cemetery in Norfolk, quote, as soon as the governing state law clearly permits it. They also asked us to ask the Attorney General for some clarification on whether or not the state law would clearly permit it. And so as of August of 2017, this was on our radar, and we were in a little bit of a holding pattern. So the statute that we're talking about is kind of the old version of Virginia Code 15.2-1812. That was revised by the General Assembly this year, and there's a new version as of July 1st of this year. But at the time we were looking at this, the statute said essentially that no locality can move, alter, or really do anything that would quote unquote interfere with any monument to a battle or a conflict or an engagement in a conflict. And then it named 15 specific conflicts that were off limits to be tampered with. We monitored the situation. The Attorney General did issue one interpretation. I think it was a response to the Director of the State Historic Resources, and that didn't really answer the question for us for our particular monument. There was also a case in Danville over a marker, I think it was a historic marker, that commemorated Sutherland Mansion, which the marker, according to the marker, is the last capital of the Confederacy. I guess that's the case. I don't know anything about Sutherland Mansion, but that was the marker. And so there was a case there, and that wasn't helpful either. I think finally the court said something along the lines of, it might matter when it was put up, but it also might matter that this doesn't really address any of the 15 specific wars or conflicts or battles that are spelled out in the statute. So we in Norfolk didn't know that for certain that we could move the statute without triggering either the criminal or the civil penalties. And the law even provided a private right of action. So even if our Commonwealth's attorney wasn't inclined to prosecute any of the council members who voted for it, we were afraid that a private citizen might. And that's exactly what started going on in Charlottesville when they made a decision to cover their Lee and I think Stonewall Jackson statues downtown. And so there were private citizens specifically asking the court to find liable the members of the council that voted for that action. So while we were sitting and waiting, we got sued by a self-styled civil rights activist. He actually didn't live in Norfolk, but he complained that we had not followed through with what we said we wanted to do back in August of 2017. And that was in circuit court and state court. And we resisted being forced to do it for a number of reasons having to do with more than this seminar's about, separation of powers, legislative immunity, and some other things. But also we weren't exactly sure we wouldn't get in trouble for doing it. We hadn't heard from the people who were opposing it, who might be opposed to moving it, but we just didn't know the answer to the question. And so we resisted it on exactly the grounds that Hank had spelled out earlier. The law of the First Amendment basically says if it's government speech, the government gets to say what it wants to say. And so what our issue was, which is kind of I don't want to say the flip side, but it's kind of a corollary of what Hank talked about. Our issue was, can a citizen force their local government to stop speaking, stop providing speech that they didn't like? And so that was the issue for our local court, and our state court said, no, it's government speech and it's actually not even really protected by the First Amendment, but by all means, there's no protection for the citizen to hear or not hear what the government wants to say. And so that case was ultimately dismissed. And so we kind of went back into our holding pattern. And then there were as we all know, there were circumstances earlier this year that changed the dynamics of where we were.
So when you were referring to that case, was that the case with where Norfolk in the Commonwealth was on the opposing side of that case, or is that a separate case that you're referring to? Because at some point, Norfolk and the Commonwealth were involved in litigation regarding the statute, and certain legal issues arose, which if you could share those with us, if that was a different case, and you could let us know how they were resolved.
Right, so that was a different case. So once the state court case was resolved, and we were a little schizophrenic about it, I think we were not unsympathetic with what the plaintiff who wanted to force the council into action wanted, but we just thought that wasn't the right way to do it. And so after that case was concluded, we began to put together a strategy to try to do an end run around the 15.2, 1812. We just couldn't tell that any ground was being made in the Charlottesville case that was really going to help us, and so we kind of gave up waiting and went into a more active role. And Mallory, if you can get photo 1, I'm going to go ahead and give the panelists a background about the monument a bit. And as I teased earlier, I think this might have a better context given the history Hank gave us. So the monument in Norfolk was located right here in sort of a traffic circle in Commercial Place. And there's a couple of large office buildings. The one you see there, the mirrored building, was the Norfolk Southern building. They've since relocated all of their offices, I think, to Roanoke. There's a park there, but it's a very prominent location right downtown. Fundraising for the monument started right after the Civil War in 1868. It didn't really go anywhere. In fact, it stalled. And so by 1890, there really had been no progress towards getting a monument completed. And then the Pickett Buchanan camp of Confederate veterans got active, started fundraising again. They only pulled together $1,000. And so they were lamenting their prospects. They decided to get help, assign one of their members, Colonel Taylor, to the job of raising more money. And he didn't do much better either. And I love this quote they found from a letter that he wrote to a woman who had just donated $25 to the fund. And he wrote, quote, "I have been discouraged of late by the many rebuffs that I have experienced in my efforts in this matter, some from quarters where least expected, that I have almost despaired of success. And it was only a few moments before I received your note when, on reading of the ceremony soon to take place in Raleigh at the unveiling of a monument there, the thought accrued to me, quote, 'Is Norfolk alone to be without a monument?' So you can see the concern here was everyone else is getting a monument and we don't have ours yet. So exactly what Hank was describing was happening, and the folks here who were working to get one erected in Norfolk felt the pressure. So they decided to scale back their plans. They originally wanted multiple figures. They scaled back their plans to one figure. They got an additional $2,500 from the city of Norfolk, bringing the grand total to $13,777. They commissioned a person who was born on Main Street in Norfolk, a sculptor named William Cooper, and it's C-O-U-P-E-R. He studied in New York at the Cooper Institute, not the same Cooper, also in Munich and also in Florence, lived in Italy for a while, was of some renown, and so he did the sculpture of the statue that's at the top. It's a Confederate soldier, it's a depiction of a Confederate soldier, a generic Confederate soldier holding a battle standard in one hand, a saber in the other, and facing north, of course. On the south side of the base of the monument, the granite base, it says the Confederate States of America, 22 February 1862, the start date. And then on the other side, the north side of the monument, it says our Confederate dead, and then it says 1861, 1865, the start and dates for the Civil War. It's very tall. Mallory, if you can go to photo 2. It's about 80 feet tall, and you can see it. This is 2 intersections away, and you can see it there against the sky, but the building next to it is a 9 or 10-story building. The pedestal itself, I think, is 65 feet before you put the figure on it. So it's undeniably a landmark, prominent. It fits all the characteristics of the type of government speech that we're talking about here. And of course, it's a war memorial under the definition of the statute. So our analysis as to where we wanted to go to try to get around the old statute really was sparked by a 2015 decision from the US Supreme Court in a sign case of all things. It was the Town of Gilbert case, and Reed versus Town of Gilbert. And it's a case that essentially said, and it was a kind of a funny opinion, but essentially it said, for any government regulation of speech, in this case signs, but it really applies to all speech, if the regulation is based on evaluating the content of the message, you're kind of in the strict scrutiny standard, that if it's a content-based regulation, it's a heightened standard, and the government's going to have kind of a hard time explaining. It's going to have to show that this is the narrowest way to do it, and this is a important governmental interest, etc. So we thought that because the old statute called out specific battles, monuments to specific battles, and because it said you couldn't do things like add Union indicia to a Confederate monument, there was enough content-based stuff in there that maybe a federal court would give us some sort of strict scrutiny review of it, and maybe we could get it invalidated. So that's kind of where we headed with our suit against the Commonwealth. We said that this is a content-based rule, and then we also threw in there a 14th Amendment deprivation of property case. Because this is owned by the city of Norfolk, it's in the right of way. It was dedicated to the city once it was finally completed in, I think, 1907. We were saying to the federal court, you can't make us keep this here forever and ever. It's our property, it's our street. To deprive us of our land and also make us maintain it forever and incur those expenses without due process of law is an intrusion on a fundamental right, And so based on those two arguments, we tried to attack the constitutionality of the statute and maybe clear the path for us to do the removal.
Now, and Adam,
So that's how I got into court with Toby.
a formidable opponent there.
I wasn't happy.
So it was a component of that was compelled speech as well, wasn't it? One of your arguments?
Right. So once you start to have to describe this, once I had to sit down and spell it out, it became apparent that what we were really asking the court to do was to relieve the city from being compelled to speak. Because the statute said you have to keep these and you have to maintain them and you shall never remove them, what we thought we were really being told was you have to keep broadcasting this message that everybody thought was great in 1907 forever and ever. And we didn't think in 2017, certainly not in 2019 when we filed the case, that it was a message we wanted to broadcast anymore. And it was a message that citizens perceived as coming from our local government. So even though it was the state saying you have to keep these, this was known as the Norfolk Confederate Monument. And it was our city council members who were hearing about it and complaining about it. They were the ones that had been sued by the self-styled civil rights activist. They were the ones that would be liable under the state statute if they moved it or changed the message in any way. So it read as local speech, and it was speech we didn't want to be broadcasting anymore. And so it became the doctrine of compelled speech, and whether we could be compelled to speak is kind of where we ended up having to go with our theory of the case.
So the localities, in this instance, because localities are a subdivision of this Commonwealth, do localities have a right to speak independently of the Commonwealth or of the federal government? What's your thought on that?
Well, the short answer is we still don't know. I think people know how this story plays out. The monument has been moved, the statute has been changed, the case between the city of Norfolk and the Commonwealth, that the Commonwealth has to be dismissed. We didn't get a ruling on anything. We withdrew the case. There is now a path to removal that didn't require invalidation of the old statute. So I don't know the answer right now. As we were trying to analyze the case and as we were preparing to argue it, it does appear from most of the Supreme Court precedent that government speech isn't the type of speech protected by the First Amendment. It's sort of a different entity, and there is some discussion, it's an old case, about whether a subsidiary or an instrumentality of a government could have any rights against a superior or sovereign component of the government. It seems like an odd idea, but we thought if there was such a thing, we had a pretty good case for it. Here we were with a statute that everybody perceives as Norfolk speech, and the General Assembly wanted us to continue engaging that speech, and we didn't want to. And so if anybody had a right to speech as against the state to not be compelled to speak, we thought at least this was a good case to call the question. But we don't know the answer, and there really, I don't think that the law was clear that there was such a right. There were a couple of interesting cases I do want to touch on, because I think the more people get into this area, it's really a rich area for advocacy and for future litigation, because we've already talked about how important the First Amendment is. It's important to protect, but it's also important to understand sort of where its limits are. And there have been some interesting First Amendment cases in the last few years before the Supreme Court. One of the ones that that I thought was one of the ones that were relevant to our case included case that was Rosenberg versus the rector and visitors of University of Virginia that started in Virginia. There's some language in there that says basically governments are entitled to say whatever they want, say what they wish. There was a case from 2015 over a specific rancher who wasn't thrilled with the federal government's funding of the Beef It's What's for Dinner campaign, and didn't want to participate in that, didn't want a portion of his money to go towards that campaign. And the court there said to government's own speech is exempt from the First Amendment. So it looks kind of like you're outside of that world. But then you get cases like Mattal versus Tam, which was from 2017. And at first it doesn't seem related, but it's a case where the lead singer of a band called the Slants, wanted to get protection under the Trademark Act for his band name. And the trademark office turned it down, so it's kind of a derogatory name. And I don't know if this makes it any better or not, but I'll tell you that the band was made up of all African Americans. In fact, that's part of the reason why he picked the name. He said in the supporting documents for his case that he chose the moniker in order to reclaim and take ownership of stereotypes about the Asian ethnicity. And so the Supreme Court said, you know, that's imposing a requirement of viewpoint neutrality on government speech would be paralyzing. We're not going to do that. We're not going to tell the government what they can and can't say. When a government, and quote, when a government entity embarks on a course of action, it necessarily takes a particular viewpoint and rejects others. So in the court's recognizing that when the government talks, not everybody's going to agree. And that's just the way it's going to have to be. So it was sort of, this was the background and the sorts of hurdles that we identified in being able to, when we were thinking we were going to have to try to convince the federal court that we would have a right of speech that could not be silent, that could not be compelled by the state.
So eventually the statute came down in Norfolk, as I understand it. So how did your local government navigate through the process in removing that statute?
I think it was mostly luck. Once the new law passed and went into effect July 1st of this year, we started preparing. The new law basically says for any of these monuments that are on public, that I think that are publicly owned, I think is what it says, you can move them, but you have to first have a public hearing, and you have to advertise the public hearing. I think it has to be advertised for 30 days. And so we picked the first possible day when we could do this. So the next city council meeting after July 1st was going to be July 7th. So we, on June the 7th, we advertised that on July the 7th, we were going to take up the question of whether this monument should be taken down from this location and moved to the Elmwood Cemetery, exactly what was in the resolution from 2015. And of course, we didn't quite get to the public hearing on July 7th without incident. So all of what has been happening countrywide in the wake of the death of George Floyd started causing the types of protests that you're seeing in Richmond. And there was one specific incident on June the 10th in Portsmouth, right across the Elizabeth River. In fact, you could probably see it from if you were standing next to this monument, because you could look out across the river. On June 10th, Portsmouth, which also has a Confederate monument in their downtown, and theirs consists of several figures, and it's much lower to the ground. It's in the street. The protest got a bit out of hand, and that evening, one of the figures was pushed over and fell on somebody who was attending the protest, a young man, father, caused a traumatic brain injury. He's in a coma. The latest news I heard about him is that he is recovering. He did not die from the incident, but he was grievously injured. And so that, I think, happened on a Wednesday evening. And so pretty quickly, Norfolk mobilized to go ahead and remove its monument at 80 feet high. the prospect of this being taken down by amateurs was a frightening one. And so as I was reporting to work on Friday morning of the 12th, the cranes were already on site. The police had already cordoned off the intersection. Mallory, if you can go to the next slide. And you can go to one more. For some time, Norfolk's monument, like others, had become an epicenter for protests. And so this kind of speech, political speech, was taking place at the site. Next slide. But by the 12th, the statue had been removed, and then in the week or a week and a half after, they were able to remove the rest of the pedestal, including removing those portions of the pedestal that had started to display the protest messages. So it was, again, a little bit of an interesting, but it's still an academic First Amendment question as to whether we ought to be removing what had become a protest site and started to have a new message, that it was being redefined in some way, maybe being taken back the way the lead singer of the Slants was saying he wanted to do, trying to change the message. But all of that was removed. To my knowledge, it has not been relocated to the Elmwood Cemetery yet. I guess eventually we will. And if we don't, and we get sued over not doing it like we said we would, I'm sure I will be defending that case as well.
All right, thank you, Adam. As to my panelists, Hank, Toby, would you like to add anything further?
I'll just add one quick thing, is the question of free speech is a real interesting one when it's truly free. That is, if Norfolk didn't have any unrest, if they didn't have any maintenance costs, right, then we could see sort of the pure notion of Norfolk doesn't want to say this. But when Norfolk has to pay and has to go into its own pocket, that arguably raises a whole nother set of issues in terms of saying we really don't want to have to speak. It's not just about our general notion of not wanting to say this thing, but now it's also about more than that, and our citizens are losing more by having this up. And I think that sort of raises some interesting questions about the state versus local issue as well. That is, if the state says you can't put it up, but we're not going to give you the money in order to cover all the costs that come with it, that sort of raises a new and interesting question.
Toby, anything further? All right, so I do have one question from one of our participants. Has a civil personal injury case resulted from the injury to the man who was injured by the toppled statue? The one in Portsmouth, I believe, that Adam, you had mentioned?
I don't know for sure. I'm sure one will come. I don't know why one wouldn't come. But there's a bunch of other stuff going on in Portsmouth. I'm not going to go into it right now. It may have been in your local paper. I'm not sure what part of Virginia all of you are coming from, but what exactly was allowed to go on that evening and what the police could or couldn't have done is, I think, going to continue to be debated. And so there may be a personal injury attorney who's just waiting for the rest of the facts to come out before they put together their complaint. I don't know of one.
I wouldn't be too surprised if we start seeing those type of cases given what's been happening across the nation. Several people, I understand, have been injured by these toppled structures. So that would be a great topic for another day. So our finalists, I'm going to move on to our finalists. Our final panelist, Mr. Toby Heidens. Mr. Heiden has been a Virginia Solicitor General since February 2018. He move this along. He previously spent 8 years as a professor at the University of Virginia School of Law. Go Wahoos! My daughter is graduating from there for her master's program. Yay! While he was there, he co-directed the Supreme Court Litigation Clinic, coached the 3-time national champion undergraduate trial advocacy team, and received an all-university teaching award. Before that, Mr. Hyten's worked at the United States Department of Justice's Office of the Solicitor General and at the international law firm in Washington, D.C. He is a former law clerk to Justice Ruth Bader Ginsburg and Chief Judge Edward R. Becker, and a graduate of Macalester College in the University of Virginia School of Law. And he has argued 10 cases before the United States Supreme Court. So Toby, my question to you is, the governor is currently a named defendant in a case opposing the removal of the Lee statue on Monument Avenue. What legal issues have been raised, and what is the current law on the removal of statues?
Sure. Well, the first question some of you might have is, why is the governor the defendant? We've been hearing about the city of Norfolk. There's been a lot of controversy involving the other statues on Monument Avenue. And the short answer to that is that the Lee statue, which Professor Chambers points out is the first one of them on Monument Avenue to go up, it's also unique for another reason. The Lee statue is the only one that's on land owned by the Commonwealth of Virginia, as opposed to the city of Richmond. So both the surrounding circle, but also the monument, the statue and the pedestal on which the statue sits are all owned by the Commonwealth of Virginia rather than the city of Richmond. So that's why the governor is the defendant rather than the city of Richmond. Some of you may remember this. It was about 2.5 months ago. There was a big press conference on Thursday, June 4th, where the governor announced to great fanfare that he was going to take down the Robert E. Lee statue from Monument Avenue. He gave a long speech about why he was going to do that. And then the following Tuesday, there was an injunction granted by a circuit court judge in Richmond in the first of, by my count now, there have actually been, by my count, 4 separate lawsuits seeking to prevent the governor from taking down the Robert E. Lee statue. And they've been by a variety of individuals. They've raised a variety of claims, so I'll just try to summarize them briefly. So I think there are several categories of state claims, and then there were a couple categories of federal claims, although the federal claims have by and large fallen by the wayside. The federal claims turned on the fact that Monument Avenue is a National Historic District, and the Lee statue is a contributing structure for that district. And so there were some allegations that it would violate federal law or federal regulations for the governor to remove the Lee statue. Those cases were disposed of pretty quickly. They were thrown out by the federal courts, and they're not really pending right now. So the other statute, the other cases that are pending by and large in state court all turn on a series of documents that happened in connection with the Commonwealth coming to own this massive statue of Robert E. Lee, because it was actually a series of transactions that led to this happening. So as Professor Chambers said, shortly after Lee died, there was an effort to raise money for a statue to honor him. And that was by a series of private entities that all sort of consolidated into this organization called the Lee Monument Association. So the Lee Monument Association had the statue. They'd raised the money for the statue. And then the question was where to put the statue. And first it was whether to put it in Virginia or somewhere else. Virginia won. The question was whether to put it in Richmond or somewhere else. Richmond won, and this from the perspective of people who wanted the statue. And then there was a question of where to put it in the city of Richmond. And there was actually a contest over this. The other main alternative was on Church. It was in what's now Church. Well, it was and is then Church Hill. There was another site that people considered in Church Hill. But eventually the site that it now is won. And I think it's fair to say it was part and parcel of a real estate development project, because it's hard to imagine for those of us who've been on Monument Avenue more recently, but in 1890, there was nothing there. It was an empty field. There were no houses. It was actually outside the city of Richmond at that point. And there was this family that owned a large tract of land in what was then Henrico County on the outskirts of the city of Richmond. And they basically agreed to donate the land for the monument, so long as the monument would be put up there, and probably part and parcel of a scheme to develop a subdivision, what we now think of as a subdivision. And so in 1887, this family gave the land to the Lee Monument Association. And then in 1890, the Lee Monument Association gave the land to the Commonwealth, when they also gave the Commonwealth the statue and the pedestal. And there's a whole series of property law arguments that the various plaintiffs make that essentially say, by virtue of either the 1887 deed, the 1890 deed, or there's a joint resolution of the General Assembly from 1889 where they authorize the governor to accept the statute and the land on behalf of the Commonwealth. And the claims that are really being litigated right now all turn on that some combination of those three documents, as a matter of the law of property, forbid the governor from removing the Lee Monument. For the lawyers on the call, it really does take you back to like 1L property, where you learn about restrictive covenants and easements and gross, and whether they run with the land or whether they're personal, and can they be perpetual, and are they void again? It's really been quite a crash course in the law of real property. So that's really where we are right now.
Interesting. So does the governor have the authority to remove the statue? And if not, who does?
Well, as the governor's lawyer, I most certainly think that the governor has the authority to remove the statue. The question, though, actually raises two different. The question raises two. There's actually two different questions in a way that I think this question helps illustrate. There's sort of one way to think about this is like when it comes to Congress, right? So if the question is whether an act of Congress violates the federal Constitution, the threshold question is, does Article 1 give the Congress the power to do something like this? And if the answer is yes, does some provision, usually of the Bill of Rights, take away a power the Congress would normally have? So I do think there is a threshold question here, even before we get to these deeds. There is a threshold question of whether Virginia law would otherwise give the governor the authority to move the Lee statue. We think the answer is yes. There's a provision of the Virginia Code 2.22402, which basically says that the governor has the exclusive authority to relocate state-owned works of art. Now, I guess you could have a debate. If that's all the statute said, we could have a debate about whether the Lee Monument is a work of art. But helpfully, there's a provision of the code that defines what work of art means. And the definition of work of art has a whole bunch of things, but two of the things it lists are statues and monuments. And whatever else the Lee Monument is, it seems pretty clear that it's both a statue and a monument. And so our view is that there's not really a question about whether the governor would have the authority to do so independent of these deeds. Although the problem, as we talk about the case, it gets all sort of wrapped up. The question of whether that governor has the authority gets all tied into the question of whether the deeds forbid it. And you do get a little bit of a snake eating its own tail. But I think the answer really is less whether the governor would have the authority to do it as an abstract matter, and more whether these documents from the late 19th century take away the authority he would otherwise have.
Interesting. And what do you believe is the outcome of that query? Do you think that the documents take the governor's authority away from removing these statues?
Well, we certainly don't think so, and we've made a lot of arguments to the court that they don't. And I think more importantly, we've also taken the view, and this really dovetails nicely on some of the points that both the previous speakers have made. I mean, we've also taken the view, both as a matter of real property, but also as sort of as a matter of democracy, that even if these documents purported to do that, that they can't do that. That we had a hearing in this case actually just 2 days ago, and I think one of the arguments that we made in the hearing is that it's sort of one of the first principles of democratic government that the government of the past cannot bind the government of the future. That the legislators or the governor of 1890 had no power to make a binding promise forever on behalf of the government of 2020. I think one of our views is that anything a governor does, his or her successor can undo. Any law a legislature passes, a future legislature can unpass or modify. But this is another area where the law is, there's less law on this. It turns out there's not a whole lot of cases where people try to use the law of real property to prevent a state from taking down a monument. In fact, I'm not aware of any other cases that involve precisely that question.
Right, this is a novel issue. So do the legal issues or challenges that vary depending on whether the statutes are on local, state, or federal property, and clarify the jurisdictional differences between them? And then and what happens to these statutes?
Yeah, absolutely. So as Adam said, one of the issues that Norfolk had in their case, the case that he and I worked on together, is there's this threshold question about whether a local government has any rights vis-a-vis its parent state government. And that, I think is fair to say, is an issue that has not been extensively litigated, and certainly not been extensively litigated recently. Obviously, when the question is whether the state can take down a state-owned monument, there's no questions like that, right? I mean, this is simply a question, there's no question of a higher, superior government authority forbidding the government from doing what they want to. And like I said, I think, there was some threshold argument that people made in this case, or when it comes to the Lee Monument, that perhaps federal law would forbid it. And now if federal law forbid it, we'd be in a much more similar situation to the one that Adam's case involved, where you have a government that is generally subordinate in some senses to another government asserting rights against them. But that pretty much dropped by the wayside. I think as the case has come to be defined, it's pretty clear that federal law does not in any way forbid the Commonwealth from taking down the Lee Monument. So I think in some ways, this one becomes a pretty close, or pretty, how do I say this? This is just about the intersection of real property and government authority. There's not these confounding questions of the sort of location of the government within the hierarchy of governments. In terms of what happens to the statues, I think that's a really interesting and really difficult question. I think that's more of a political and social question than it is a legal question, generally speaking. But that doesn't mean it's not a really hard question. It's just it means that I don't know if I have any specialized expertise in helping anyone answer how the question should be answered.
Right. So I guess if statues are considered real property, then real property laws would apply. Would you say that these statues would be considered real property?
I mean, well, at the risk of saying something that my property professor would tell me I'm wrong about, I think the statue itself is probably personal property. It's probably a chattel. But then when it gets really confusing is, I'm remembering from 1L property, there's this notion of fixtures that once you attach something to the real estate, it becomes part of the real estate. So, I mean, I think at least until it was bolted into the pedestal, it was personal property, not real property. I don't know whether bolting it to the pedestal makes it real property or attaches it to the real estate. But I think so. I think one of the things that makes these issues so fascinating is you don't get a lot of these, again, very, very technical, in the weeds 1L doctrines of property with really difficult questions. Both, I definitely take the point that it's not really clear that governments have free speech rights exactly, but I certainly think there are free speech values at stake, right? That when the government, I agree with Adam that and Professor Chambers, that the law on whether governments actually have free speech rights, or if it's more that when the government speaks from itself, the government isn't subject to the constraints of the free speech clause. But I think that, I think there certainly are free speech values in play, especially in situations where people, are inevitably going to attribute the message of these monuments to the governments that own them, that own the property in which they are, and that maintain them. So I think it's a really difficult and very important question right now.
Yeah. So would you say that, can you remember a point in time where property rights intersected with First Amendment issues?
Well, I think Professor Chambers is actually right. The Summum case obviously was a case where the property rights were intersecting. That involved a park, and people wanted to put up things in their park. There have been references. So before I took my current job, I was a law professor at UVA. So I still live in Charlottesville. I'm calling you from my house in Charlottesville, which is 2 blocks away from Charlottesville's Robert E. Lee statue, which is one of the things that's been mentioned throughout this. But the other thing is that when I drive to Richmond, this is another interesting issue. When I drive to Richmond on 64, I pass a massive flagpole with a massive Confederate flag that someone put up after the Unite the Right, or around the time of the Unite the Right rally. It's a massive, massive, massive flagpole with a massive, massive Confederate flag that is clearly and plainly visible to every single person who drives past it on I-64. And that's on private land. And so there are additional wrinkles when it comes to that, because perhaps not surprisingly, a lot of people are not happy that there's a massive Confederate flag clearly visible from I-64. But the fact that it is on private property creates an additional wrinkle in terms of the ability, if any, of people to do anything about that.
So on that note, I'm going to open it up to my other panelists. Do you have anything, any comments or any questions or anything further to add? I know that that was quite a presentation with a lot, rich with information. So let me know which one of you guys want to go first.
Actually, I just want to ask a question. With the Lee Monument, given what folks are doing to it, does the state have any obligation to clean it up until the court tells the governor what he can or can't do with it?
That's a great question. It has come up in the litigation. So for those who may not be from Richmond or may not have seen photographs, for quite some time now, the Lee Monument in Richmond is, and I say this advisedly, completely covered with graffiti. This is not a little bit of graffiti. The entire pedestal, the statue itself, I don't think has graffiti on it, but the pedestal is entirely covered with graffiti, and it's been entirely covered with graffiti for quite a long time at this point. And one of the issues that has come up in the case is that the plaintiffs have, one of the claims they've made is that not only is the governor not allowed to take it down, but under the deed, one of the deeds, he's required to, what is it? Protect and affectionately defend it. It's very flowery, like 19th century language, but they've essentially argued that by not preventing people from putting graffiti on the statue and from not cleaning up the graffiti on the statue, that is an additional violation. So far, the court has not ruled on that, has not seemed inclined to rule on that. I think one of the answers, it might go back to the point that Professor Chambers mentioned earlier with regard to Richmond. I think one of the responses when it's come up in court hearings, the truthful answer, well, one answer that we have given when asked is we say, we have every reason to believe that the moment that the state were to paint over or remove any of that graffiti, it would instantly be replaced. The moment that basically, even assuming that we could safely do that, there is every reason to believe that the moment that the state officials who removed the graffiti left, the graffiti would go right back up. There was some evidence, I think I saw this when I was in Richmond, there appeared to be a dedicated back and forth. This is before the Stonewall Jackson statue went down, which is sort of the pedestal of that is basically a brick shape. And so it would get graffitied, and then people would show up and paint over the graffiti, and then people would graffiti over the painted over graffiti. And this went on for a number of days involving the Stonewall Jackson statue before the Stonewall Jackson statue went down. But the short answer is yes, that is something that people have raised. And that has in fact been one of the arguments that we have made about why you should not construe these deeds as creating that sort of obligation. Because if you really take it seriously, it would suggest that the governor or the state government would be under a perpetual obligation to essentially post guards and to then paint over any graffiti. Because I mean, we're now several months in. I think there's every reason to believe that as long as that statue is up, people are going to put graffiti on it, no matter how many times it's taken off, no matter how often it's guarded. So short of posting 24/7 guards at the monument to make sure that doesn't happen, it seems like this is just going to keep happening over and over again.
Mm-hmm. Any other comments?
Yeah, I actually was going to ask the opposite. As a local government attorney, I worried a little bit, I think it's moot now, but I worried a little bit about whether for us, because it was in the street, but maybe at this point, given how long it's been going on with the Lee statue, that there might be a sort of a traditional public forum created, that if you let the public convene and speak and handbill and display their messages and do what's been going on there for some time. I think at one point I saw pictures of projections and all kinds of creative ways to display different messages, knowing they would be seen, knowing what their audience was, that might be an area where you couldn't, even if you had an obligation to take it down, that there might be some First Amendment rights of people to be in a traditional public forum and to speak and that you might be enjoined from taking it down. I didn't know if that's just an academic question or if that's another reason why maybe just not the practicality of being unable to succeed with cleaning it, but maybe it's not the right thing to do to clean it, given what it has become in the past few months. Do you worry about the traditional public forum effect of where these sort of routine, repeated protests and assemblies are occurring what effect that might have on the ability of the government to shut it down?
I think it's certainly an argument that I could imagine someone making. Yeah, and again, for folks who aren't from Richmond or haven't been down to see it, you can Google this quite easily. But yeah, there's developed quite a tradition of people projecting things, usually onto the statue, not even onto the pedestal. You know, off the top of my head, and I don't spend most nights in Richmond, but I've just seen these usually on the internet. I've seen George Floyd projected onto it. Congressman Lewis, after he passed, I believe he was projected onto it at some point. On the anniversary of the Unite the Right rally, Heather Heyer's picture was projected onto it. I've seen BLM projected onto it. So there've been a bunch of different things projected onto, like I said, usually the statue, which it turns out at night, a relatively smooth piece of metal makes a pretty decent projection screen to project images onto when it's evening in Richmond. And I do think there is obviously a tension between permitting people to engage in private expression on government property and then restricting it. And it can create real challenges once you do take things down. I think I think this is consistent with everything we would have said in court. I think as the government's lawyer, what I would say right now is that the government has not authorized people to put graffiti on the Robert E. Lee pedestal. It's not. So for anyone who's ever been to Charlottesville, there's actually a First Amendment monument in Charlottesville, and there are these large slate walls that people are not only allowed to, but encouraged to write on with chalk. In fact, there's even often chalk provided. But you've got to give a lot of thought to that from a matter of First Amendment principles. And my understanding as a citizen, not as a lawyer, has always been the principles are anyone can write anything they want, but it's chalk, so anyone can erase anything that they want, anyone can write over anything that they want, and it's going to periodically rain, which is going to wash it all off. And my sense possibly is that the city sprays it down on some sort of periodic, regular basis. You know, every Tuesday night, we're going to spray it down. And it doesn't matter what it says, and it doesn't matter what anybody wrote. Nothing's going to go past 1 week, no matter how long that is. You know, that's a situation where a government has deliberately created a forum where people are allowed to write things on a piece of government-owned property. Actually, I'm not sure if that's actually technically owned by the government or if it's still owned by the private entity that donated it. But yeah, these are really difficult and challenging questions. And of course, you know, these aren't just First Amendment questions. They're First Amendment questions that arise in context of urgent concern about racial justice and ongoing concerns about. And I mean, the Lee Monument's not just some government speech. The Lee Monument is a massive statue to the General-in-Chief of the Army of Northern Virginia from the Civil War. So I mean, there's also a really important and interesting intersection between those two pieces of it here as well.
That's I'll tell you, Toby, I was thinking of exactly that slate thing in Charlottesville, as well as, and this is also for folks who have been to Charlottesville and certain areas, there's a bridge called Beta Bridge that folks paint almost every night. And it's interesting because there's just sort of an agreement, I guess, that, yeah, you can go ahead and paint Beta Bridge, but no one expects the stuff to be up there more than a day, and it just gets taken care of. So the idea that one might present a place to put their thoughts is interesting, because folks, like I say, have just sort of taken over the Lee statue as a place to put ideas. And when the government says, as Adam says, when the government says, okay, what does that mean moving forward? If we now get used to the concept of that's a place to go to put stuff up, and we'll call it street art instead of graffiti, for example. It just gets to be a real interesting sort of legal-ish question. So no, great point.
Now, actually, I have several questions from participants. I don't think we're going to be able to get through them all. So I'm going to ask them. We have about a good 10, 12 minutes. I'm going to try to at least get 3 questions out. So the first question is, does the legal analysis that is applied to the removal of statues also apply to portraits in local courthouses? And if so, do other amendments, such as the 6th Amendment, come into play, and which must also be taken into consideration? And between the 2 amendments, which should be given greater weight in a courtroom? This first question is like a 4-part question. So I guess the first part is, does the legal analysis that is applied to local, to the removal of statues also apply to portraits in the local courthouse? And in doing so, consider the 6th Amendment and how it comes into play. Who would like to take that question? Do I have takers?
A law professor or a former law professor question.
Good move, Adam. So, Nick, Toby, one of you are on the hot seat.
I'll throw out a little bit. It seems as though the same issues in terms of First Amendment doctrine, that the doctrine issue would be the same, but the values issue is completely different, right? That is the 6th Amendment values that come in, and frankly, I'd be okay to even think about 6th Amendment doctrine coming in and saying, if everybody on the jury knows that there are Confederate generals who had a certain thought process about the value of African-American life, right? If everyone knows that is something that may be going through jurors' minds when they are thinking about whether it's a white defendant, a black defendant, whoever they're thinking about, if that's going through their mind, then that arguably raises some slightly different questions and some slightly different issues out there about what to do with a painting. There are some live questions out there. I can't remember the jurisdiction, but there's some jurisdictions, and a friend of mine actually had a case where he said, look, I want those down. And I don't remember how that case came out, but those were some of the issues he was pushing, and I thought they were fascinating. I don't know that there's a single answer, but that's where the doctrine question and the values question really collide with those 2 amendments.
Okay. So I do have another, the next question that was asked was, what is the expected timeline to resolve the Lee statute removal? And I think that one's possibly more directed towards Toby. So Toby, can you share what is anticipated with respect to the Lee statute and the ongoing litigation?
Yeah, and the short answer is that we don't know. So we had a hearing on Tuesday for our demurrer, which is the state court equivalent of a motion to dismiss for failure to state a claim. If that were granted, that would be a ruling in our favor. I fully expect, though, even if that were granted, the plaintiffs would appeal to the Supreme Court of Virginia and would seek to have the injunction maintained, sort of pending their appeal. I mean, I think one of the realities in this case that everybody's aware of is it seems likely that if the injunction weren't in effect for any length of time, the statute would come down. And once the statute comes down, it's very, very unlikely that it's ever going to go back up again. And not because it's a matter of doctrine that you couldn't do that, but because I think, judges are people too. And I think judges would recognize that it's one thing, as the judge has said, it's one thing to say that it has to stay up a little bit longer. It's another thing to say that once it's been taken down, presumably with great fanfare and ceremony, that a court would actually order it to go back up. And so I think as a practical matter, it's highly likely that the plaintiffs would ask and with some, and that judges may well be persuaded to maintain the injunction until the legal challenges are finally determined, with the understanding that once it goes down, it will not go back up again. So I think if the motion to dismiss were granted, that could happen as early as next week. I still don't think it would necessarily happen right away, because I think there'd be wrangling about a stay pending appeal. If that motion is not granted in full, we are currently still negotiating a trial date, but it looks like that would be near the back half of October. That would then require a ruling by the trial court. And again, I'm quite certain that no matter what way the trial court rules, the losing party will appeal to the Supreme Court of Virginia. So I think realistically, it's more likely to be measured in months than days, I would say. But I'm very hopeful that it's not measured in a period beyond months. So I think is the best answer I can give.
Well, given that the first several constitutional amendments may be implicated with respect to removing those statutes, do you think that this is a case that could make it to the U.S. Supreme Court?
I don't, never say never. I think we'd be the ones that would be more likely to take it to the U.S. Supreme Court. I think this fundamentally is going to involve questions of Virginia law and the scope of the governor's authority under Virginia law and the meaning of Virginia property law. I guess I'd never say never, but I think the issues in this case are fundamentally more issues, at least as the case has currently been formulated, more issues of state law than federal law, and you can't go to the U.S. Supreme Court unless you have an issue of federal law.
Right. Our next question is more of a personal, as it applies to you all who have been litigating these cases. So I guess these would probably go to both Adam and Toby. Does litigating these cases ever wear on your well-being? I imagine because of the substance of these issues and the underlying issues, and how do you cope with that?
I think I can respond pretty succinctly, having been through a couple rounds on both sides, one trying to stop somebody from forcing us to move it, and then another time trying to do an end run around a statute that we thought was preventing the removal. I've reconciled it for myself early on with exactly kind of where we ended up with the new statute, which is to say, this is really a question for the public. It's a question for the citizens of Norfolk. It's a debate that ought to be had between them and the city council. And I may have my own opinion, but I don't get to decide. I think the community should decide, and the methodology that the General Assembly put together to require a public hearing, there's actually even a waiting period built in that after the decision, the locality is supposed to wait another 30 days to see if a historical society or a museum or some interested group might file a proposal to take the monument off your hands. I think that's the right approach. I think it ought to be community engagement. And as one of the cases I alluded to earlier conceded, you're never going to make everybody happy, but the only way you're going to know whether you're making most of the people happy or the people who, or who's more right and who's more wrong is to have the debate and have the discussion. So I'm happy for it to be a matter of a public hearing.
So I'm going to move on. I think this is possibly maybe the last question of this town hall. And if the government does not have the obligation to protect, does the government have an obligation to prosecute those who deface and damage the property? And so what is your thought on that?
I'll be quick. From a criminal law professor's perspective, I wouldn't say there's any obligation. There is an obligation to ask how to do your prosecutorial discretion decision making.
Right.
But that's an obligation that comes with every crime one sees. So that's kind of how I would look at it.
Any other responses? Okay, so we might have time for one more question. And give me 1 second. I will see if I could find that one for you guys. Okay. All right, here we go. In terms of the law, do any of you see any difference between the discourse surrounding statutes and that surrounding the names of schools, those schools bearing the names of leaders of the Confederacy? And so I think this would be a good question for a local attorney and a professor. Toby, you get a break on this one, maybe.
Hey, Toby's a recovering professor. There's no, and he will, and I guarantee you, he will come. I guarantee you, he will come back to the academy after. I guarantee you that.
You're right. All right. So we just go to Toby then. All right. But I'm going to start off with you, Hank, and then we're going to let Toby comment.
This is, in some ways, it's a very easy one. I don't see that much of a difference between the two. But of course, my kid goes to a school that until a couple weeks ago had its mascot as the Rebels. So my take is there's not that much difference. And here's the reason why. The statues have been where they have been for a long time. So my take is that we're really asking whether we want to retain the statues, not whether we want to tear them down. Right? For everyone who says you're erasing history, no. Lee's statue has been where it has been for 130 years. We can't erase that history. The question is, do we want to keep it up? So other than the dollars and cents involved in taking them down, I view the issue as being largely the same. It's the government saying this is something we want to say and something we want to project. So in that respect, I view them fundamentally as being the same.
And Toby, do you want to add to that, or?
Yeah, I think doctrinally they're extremely similar. I mean, you know, if anything, I think it's tough. I mean, if anything, I think it's easy. I could make the case that the schools are even more problematic because people wear, you know, so there was a case, we had some involvement at the early stages of discussions anyway. Students who participate in sports or in the band, they wear the school's mascot, right? They wear, the individual students are asked to wear items of clothing that have this mascot or have the name. And so that adds to another level of, to some degree, you're conscripting the individual to now carry the message that they themselves might find quite reasonably deeply problematic and difficult. So, you know, I think if anything, that may create even greater problems because it adds another, I guess this is a doctrinal point, it adds another level of First Amendment inquiry when it's not just the name of the school that you walk under as you walk into school. And of course, then you start getting into the right of an education and you know, so I think if anything, the school situation may be more problematic in some ways. But I agree, fundamentally, they raise the same basic issues. I think the issues are basically fundamentally very similar.
All right, you know, I'm pretty sure Adam has the comments, but Adam, I'm going to need to wrap it up. I'm going to have to wrap up this town hall. We are coming close in time. This has been very, very, very informative. I want to thank all of our panelists today for this webinar. There was so much to cover, and you all did a wonderful job in providing a substantive and interesting program. I also want to thank all the participants for joining the webinar and taking time to become aware of such a dynamic issue. I definitely have to thank Mallory Ralston, who's in the background, and without her assistance, this would have been very difficult to manage. So thank you, Mallory. And in parting, please keep a lookout for our next Time to Talk town hall. There'll be another one coming up, and you'll be getting notice of that. I want to thank you all for your time. And I don't know how to thank my panelists enough. You all did an unbelievable job. So with that, I will say till we next meet. See you soon.
Thank you, Zeta.
Thanks a bunch.